The fraud, money laundering and corruption trial of former President Jacob Zuma set to get underway this morning, around about 10 o'clock at the High Court in Pietermaritzburg. Zuma's latest bid to have lead prosecutor Billy Downer removed from his trial had failed after the Supreme Court of Appeal had dismissed it last month. And now to Lasizwe Simelane, for viewers just tuning in, there's now talk of private prosecution as well. To Lasizwe Simelane and Siphamandla Goge for us waiting anxiously for the former president to arrive in about an hour and a half from now. Tulas, let's start with you. Private prosecution, hearing from a legal expert earlier, for the moment going to have no bearing on this case, unless, of course, it does go ahead as private prosecution.
And the main reason, Gareth, is that at the moment, as we speak, there isn't a private prosecution that is actually on the go against Advocate Billy Downer in terms of Section 7 of the Criminal Procedure Act. We don't have such a process at the moment. What we do have, though, is confirmation from the NPA that the Director of Public Prosecutions for KwaZulu-Natal has declined to prosecute Advocate Billy Downer in line with the charges that Mr. Zuma would like him to face, charges that have to do with, in a way, they talk to the allegation that Mr. Zuma and his defense make that Advocate Billy Downer has basically behaved in a manner that is unbecoming and actually amounts to criminal conduct in terms of how prosecutors are supposed to carry themselves. With the Director of Public Prosecutions for KwaZulu-Natal refusing to prosecute Advocate Billy Downer, that ordinarily, in terms of Section 7 of the Criminal Procedure Act, would pave the way for a certificate to be issued to whomever would want to carry out a private prosecution to then be able to do that. But there are conditions attached to that include that person seeking to pursue a private prosecution must have an interest that is sufficient enough in the matter, and the prosecution would then be carried out in their name with a number of other technicalities that need to be adhered to. And then in that instance we would have a private prosecution of Billy Downer. But as things stand, there is nothing before the courts by way of a private prosecution. That's the one area of law that we expect will feature in the proceedings when they get underway here at the High Court in Pietermaritzburg. The other I will talk to in just a moment with Melu Sikulu, a legal expert who joins me. But before I do that, let me take you to eNCA's Siphamandla Goge, who is on standby. It's pouring in Pietermaritzburg. Siphamandla, outside it's pouring, but what do we expect by way of proceedings inside court? The NPA indicating that they are ready to go.
Indeed, well, the state has said that they are ready to commence with this trial and they are ready to call their first witness. Last time they indicated that, well, they hope there will not be further delays because they want to get on with it. But I can tell you that it's not going to be easy for them to call their first witness. Everything today will boil down on what Judge Pete Koen will rule, because there is an expectation that the former president's legal team will bring an application to have these proceedings postponed, because they are saying they are not done with their fight to have Billy Downer removed. I can tell you that former President Jacob Zuma's supporters and political allies will start streaming through the door on my left. They will come here to show their support. But inside court, of course, security is tight. Bongamkize will show you the passage here. Members of the Presidential Protection Unit and Services, they are here to ensure that when the former president arrives, everything is on track, and they don't want to take chances. Their mere presence signals that the former president will be coming, and in terms of security, it's what they always do to ensure that they play everything is in order. So this is the passage that the former president will use. Usually when he comes to court, he will come that way, and then he will make his way all the way down there, turn left, go inside courtroom A, and this hallway will be packed with security personnel and police as well, including political allies of the former president. president. We expect the suspended Secretary General of the ANC, Magashule, to come and show his support to the former president, and other political allies that have been coming here to show their support to the former president. So today we expect that it's not going to be an easy day in terms of the proceedings just starting and finishing. There will be legal arguments, particularly about what the former president will be wanting and pushing for. That, listen, give me some time. I've decided to deal with this matter. You dismissed my application and I'm not done with the matter. I still want Advocate Billy Downer as the state lead prosecutor to be removed from prosecuting myself. I will not get a fair trial. I've said that before. So today we expect that there will be arguments in that regard, and Judge Bidkun will decide what to do, how to rule in that matter. But the judge himself has said that he would want to see this matter getting underway, saying it's not in the interest of justice to have this matter dragging for a very long time. So those arguments will take place inside court today, and the former president is expected to be physically present, because as far as we know, there is nothing that prevents him from coming to court. If he does not come, he will need to present a compelling reason why he didn't come. But the mere presence of his protectors here and state and security personnel tells you that he is expected to be physically present.
Right, that is eNCA's Siphamandla Goke. He'll be our eyes and ears inside the courtroom A, when the proceedings do get underway. Gareth, earlier on I talked about one area of law that has to do with private prosecution, Section 7 of the Criminal Procedure Act. The other area of law that I do expect we'll be hearing a lot about when the proceedings get underway is the Superior Courts Act, and in particular Section 17(2)(f). We are learning the law, all of us. It's a steep learning curve. Because, as one commentator said, Gareth, it would seem that the defense of former President Jacob Zuma basically has all these procedural parts of the law and substantive law before them, and they're going through it with a fine-tooth comb, and you would expect no less, really, of any defense, because they do have a responsibility to mount a formidable defense in his name. Let's bring up the section of the law that I'm talking about. It's the Superior Courts Act, Section 17(2)(f). That has to do with the referral of a matter to the President of the Supreme Court. So as you and I know, as we bring it up on screen, the decision of the majority of the justices, of the judges of the Supreme Court of Appeal, is the decision of the court. But here's the proviso in Section 17(2)(f). It says the decision of the majority of the judges considering an application referred to in paragraph B, or the decision of the court, as the case may be, to grant or refuse the application shall be final. There's the kicker. Provided that the President of the Supreme Court of Appeal may, in exceptional circumstances, whether of his or her own accord, or an application filed within 1 month of the decision, refer the decision to the court for reconsideration and, if necessary, variation. So there are a few conditions there. Exceptional circumstances, the President of the Supreme Court of Appeal may, of his or her own accord, within 1 month of the decision, refer the decision to the court for reconsideration and, if necessary, variation. And that, Gareth, is the door that former President Jacob Zuma's legal team will be hoping to open as they come to the court here in Pietermaritzburg. Melusi Xulu joins me to unpack it all. It never stops, does it, Melusi? This particular section of the law is really where Mr. Zuma's, that's the door that he's knocking at the moment.
Yes, we expect that that is the position they will use in this case, because it's part of the law. And what we've seen with the defense of the former president is that every aspect that they can use to advance their case, they will use. One, there's a school of thought that will say maybe it's a Stalingrad defense, but if it's available for them and if they feel it's what they need to have a fair trial, I suppose they will use that angle. Because as it says in the section, in exceptional circumstances, the judge president may reconsider, or there may be a variation. So we'll see how they'll bring that about, because it's something that is available for them to use for their case.
Not being a practicing attorney, I don't imagine this is a section that's used a lot. But the fact that it is there means that, you can, as you say, if you are mounting a Stalingrad kind of defense that says nothing, not an inch will be given for free, you will have to fight for every inch of this case that you'll be hoping to advance.
Yes, I suppose that's a position, but at the same time, one may say it's a Stalingrad defense that they are using. It's a tactic. But if you heard what they said at the press conference, what they are advancing for, according to them, is that they are ready for the trial. But according to them, they want it to be a fair trial. So that is their position. But what will be the position of the NPA? I suppose they'll want to say this is an unreasonable delay. They will raise Section 342A the application in the Criminal Procedure Act, and they'll say, can the trial just proceed today because there has been unreasonable delay? But what will be a decision that must be made by the honorable judge is that should they be allowed to have this application in terms of the section of the Superior Court Act? That will be interesting to see.
How high are the stakes, lastly, Melusi, how high are the stakes for the NPA itself? Because, prosecuting authority vests with them, the National Prosecuting Authority, and they should do their work without fear, favor, or prejudice. And I suppose at the same time, they don't want to be seen to be dictated to by an accused person in that, he should be able to say, oh, no, I don't want this prosecutor, give me any other prosecutor and I'll be able to proceed.
Well, as we know, the NPA is the dominant latest. They're the one that decide when the trial must proceed. They're the one that decide who is the best person to proceed with the trial. But here's what I've been thinking about for some time since last year. If you read into it, it looks like the defense also wants to say if the advocate Billy Downer is removed, isn't the case tainted enough for the case not to proceed?
I see. So you are saying to me, right now in public, they are saying,
for now,
remove Billy Downer, we will proceed even today.
Yes.
You are actually seeing it differently, that it might open a door to say, you removing Billy Downer shows that this case is tainted.
That's the second phase that I'm expecting, but that's my speculation.
So, we are really in for some interesting times in as far as the legal strategies are concerned. Melus Tuld, I've got to thank you for your time and your insights. So that's how it's looking. It's almost like a courtroom drama series that is endless. It's had us gripped and focused for 17 years. And former President Jacob Zuma celebrates his 80th birthday tomorrow. Or the 12th of April. If the NPA has its way, his supporters such as Carl Niehaus and others who arrived earlier on here at the court will be singing happy birthday to him in the corridors of the High Court here in Pietermaritzburg. But if his defense has its way, he'll be at home in Nkandla awaiting the decision of the President of the Supreme Court of Appeal on whether or not she will be intervening to ensure that the decision to refuse him leave to appeal to the SCA is sort of revisited and reconsidered.
So two things. One is we're now at the door of exceptional circumstance. Thulasizwe Simelane, thanks for unpacking that piece of law for us. And the other, of course, is a courtroom drama. The question I suppose we all have is who has the script for the courtroom drama? Thulasizwe Simelane and Siphamandla Goge. For the moment, in the rain in Pietermaritzburg for us. We're back to them again a little bit later as we head up to looking for a clock. 18 minutes after 8. The trial set to get underway, or set to resume rather, just before 10 o'clock this morning.